This is a remake of basic ideas for using common law. We are all constantly learning new things every day. Again, I would like to remind the audience that I am not an attorney. We will be going over a basic strategy for using common law. Let's define what common law is to the common man or woman. Here is the definition of common law from the word common in the Webster's 1828 dictionary. Remember, the 1828 dictionary is the go-to dictionary for the Supreme Court. Let me also advise, if a definition pops up in this video, please take the time to look it up. I will post a link to the website below. Common law in Great Britain and the United States, the unwritten law. I like to say that it is unwritten because you have not written it yet. The law that receives its binding force from immemorial usage and universal reception in distinction from written or statute law. This is why one can use any timeless source to be binding on the courts. This is also why case law is common law to attorneys, because case law is the legal society's immemorial usage, and it always has been. That body of rules, principles, and customs which have been received from our ancestors and by which courts have been governed in their judicial decisions, the evidence of this law is to be found in reports of those decisions and the records of the courts. See, only the evidence of this law is to be found in the decisions and records of the courts, otherwise known as case law, and common law governs the courts in their judicial decisions, or that is the way it's supposed to be. Some of these rules may have originated in edicts or statutes which are now lost, or in the terms and conditions of particular grants or charters, but it is most probable that many of them originated in judicial decisions founded on natural justice and equity or on local customs. I interpret this last part to mean if case law is not founded on natural justice and equity, then it is not real law. Most of the rules I have found for common law at one time were edicts and statutes expanding the people's rights, but there are only so many rights you can legislate before one's job as a legislature will be to start taking those rights away. Carl Lentz is the man I will be using as an example on how this works. He has a website, broadmind.org. The documents I will be presenting came from there. Keep in mind, we as the people do not need a law degree to operate in the courtrooms, and we also don't have to play by the same rules, statutes, and codes as attorneys have to play by, because we never joined the legal society. One example of a statute that turned into common law was the Pleadings in English Act of 1362. After this statute expired, it was common law that all parties involved needed to understand the language being used in the case. We have all heard people say to understand means to stand under the state's authority. I would like to add a different perspective on that word. Understand means to support and hold in mind the same ideas. So when a cop asks if you understand, he is asking if you believe that you are breaking the law, doing wrong, as the cop does. Do you both have the same idea in mind? Comprehend means to take in, to conceive, to possess, or have in mind, or have an idea. This is why we can comprehend their laws but do not understand them. I comprehend a plant is illegal, but I cannot understand how something that grows naturally is not lawful. It does not make any sense to me. Words are everything in a courtroom, and the pen is mightier than the sword. With these things in mind, now I will start to break down what he is doing in these documents. On the left side of the paper, one must identify the parties involved. Remember, we do not have to play like attorneys because we are not part of their legal society, so we would want any juror to be able to understand the paperwork we are writing. That being said, we are going to use plain English from Webster's 1828 dictionary. He does not capitalize the I, a man, because capitalization diminishes one's rights. Underneath, he titles himself prosecutor. He draws a line between himself and the defendant. As I would write pursuing, I agree the defendant should be titled the wrongdoer, and that is why I would pursue the wrongdoer in the name of justice. Always put to me at and not in the court on the top of the page. On the right side of the page, put the nature of the document. On this document, he says nature of case, claim, and then he claims forgery. This is to let the opponent know what the body of your paperwork is about. For instance, if this was a notice, he would write notice and a few words of why. If one knows the grievances to be true, it needs to be verified by oath or affirmation. Under the heading of the paperwork, he writes, I require a court of record trial by jury. Remember, the courts in government are set up to serve the public, even if it does not seem that way at this time. We, the people, need to remind them of their true obligations. In the body of the brief, he illustrates the wrongs that the Department of Human Resources put him through and the compensation he requires. He gives his word to this by the verified oath in open court and signs the document. He uses his thumbprint as his court seal. Personally, I love that idea. Okay, this is all good and great, but how do I use it? This is America. You can sue anybody for any reason. A cop is no exception, but his badge is, and statutes will prevent one from doing this with an attorney, as those rules apply to persons within the legal community. Hypothetically, let's say a people is pulled over, and his person has a small amount of illegal substance within his vicinity. Let's say this substance is marijuana in nature. The officer violates the people's Fourth Amendment right and legally but not lawfully searches the property, car of said people, and then proceeds to handcuff him and take him to jail. We have all seen this and know that more harm comes from the policy officer than the one who's smoking weed. This is why it is becoming legal slowly across this great nation of ours. There is nothing stopping a said people from suing Bob, the man operating a badge, for trespass on his rights. Rights are property. Read John Locke to get more ideas on how your rights and your persons are property of the man. Remember, binding force from immemorial usage. John Locke is still studied in schools like Yale for his book, The Two Treatises of Government, and many others. The second treatise is the most influential writing that founding fathers studied for the ideas of breaking away from England and writing the Constitution for the people of the United States. Speaking of constitutions, the Magna Carta just had its 800th birthday on June 15, 2015. Now, let me get back to the suit. I, one of the people, claim you, Bob, the man, had no right to violate my rights to be secure my persons, houses, papers, and effects, essentially property. CF, meaning compared to, Article 4 of the Bill of Rights. Always compare to their legal society's beliefs. If one starts writing in their language and code, that implies, and they presume, you are learned in those codes and statutes. We are self-governing if we choose to be. Then Bob proceeded to administer my persons into a cage called jail. This needs to be in the form of a claim, as shown earlier. The only thing a policy officer can do is make a criminal complaint, attorneys as well, in criminal matters. A claim is always heard before a complaint. Would you rather listen to someone claim something or complain about it? Would you rather complain about your rights being violated or claim your rights and demand redress? A claim is to call for, by virtue of authority, a right or supposed right, to challenge as a right. Make your paperwork very simple as shown in Carl Lentz's example. File it with the civil court. Make sure you get your own case number for that claim. Remember, the public's use of the common law is only in the civil arena, unless people exercise the right to use a common law grand jury. Go to the criminal court on the court date, and when your case is called, take your claim and put it in front of the jury if they are not willing to discharge the charges. If it goes to a jury, make the trial on belief of right and wrong. Hopefully we can appeal to the people's better nature. Mr. Bob, was it worth violating my privacy, violating my trust for the officers who are supposed to be there to serve and protect me, violating my rights and my persons with a quite unpleasant trip to the county jail? Bob, please let me just ask, what did I do to you? Did I harm or injure anybody? Did I cause you financial loss? Bob, did I do you wrong in some kind of way? No, then why did you, Bob, inflict this trauma on my being? Now, Bob, I understand that is the belief of the legal society that weed is wrong, but I also operate a normal person, and for normal persons, not only is weed okay, but it's a really good thing to do. The idea is to make your own case with your own beliefs and see what 12 people believe is moral and right. Let us just hope 12 out of 12 people are reasonable enough for this. Even if the 12 are not, it only takes one to nullify a jury. You might not win, but that does not mean you will lose. Everyone sees how much harm officers are doing to the public in the news. We, the people, need to start standing up together and claiming our rights, putting it in front of a jury and see what the public really thinks. If one wins the civil case, the criminal complaint will be discharged. Think if most people whose rights get violated charged the man or woman involved. I believe policy officers would be friendlier to the public if they thought they might be sued personally for their actions every time they interact with us. I say we, the activists, we, the protesters, we, the people, sick of seeing our country being ran 6 feet into the ground. I say we push back with words and intelligence, using a system of law that history has tried to bury. I comprehend the skepticism on how this could work, but keep in mind the Church of Scientology got religious status by the government and the IRS, holding them hostage with 2,400 lawsuits. Also, think about our government. We have one president and 535 persons for both the House and the Senate that we elect. The court system is the only branch of government we all have access to all the time. Seems to me that would be the place to start change from within the system without becoming a part of it. Before anyone tries any of this, they should be a man or woman of their word and inform the state of not wishing to participate in their society anymore. Write out a claim of right and a notice of intent. Before we have any more violence in the streets, we, the people, should stand with one another in a court of law and try to prove that the pen is mightier than the sword. Thank you for watching. I am Just Conspiracy, and I would just like to conspire with other good people on this planet to leave a better world for our children than the one we were all born into.